The hearing was supposed to take 45 minutes. My daughter had told me that herself, standing in my kitchen with that patient smile she'd been wearing for the past 8 months, the one that didn't quite reach her eyes. "It's just a formality, Mom. You go in, the doctor presents his assessment, the judge reviews it, and then we can finally get you the help you need." She'd squeezed my hand when she said it. I remember thinking she learned that from somewhere. That squeeze. Practiced. What she didn't know, what neither she nor her husband Ryan knew, was that I had sat in that exact courtroom 214 times over the course of my career. I knew which chair creaked. I knew that the overhead light above the respondent's table flickered every 8 seconds because the building manager had been putting off replacing the ballast since 2019. I knew that Judge Patricia Okafor took exactly 3 sips of her coffee before she called the hearing to order, and that when she recognized someone, she went very, very still. She went still the moment I walked through the door. I'll get to that. My name is Eleanor Hartley. I am 68 years old. I spent 31 years as a family court judge in Dane County, Wisconsin, the last 12 of those as chief judge. I have presided over guardianship hearings, competency proceedings, conservatorship battles, and every flavor of family dissolution you can imagine. I have watched families tear themselves apart over lake houses and stock portfolios and sentimental jewelry that wasn't worth $40 at a pawn shop. I retired 4 years ago because my knees were telling me something my pride wasn't ready to hear. I live alone in the house where I raised my 2 children, 4,200 square feet of mid-century modern on Lake Mendota, the kind of house that people slow down to look at when they drive past. My late husband Gerald bought it in 1987 for what seemed like an outrageous sum. He passed in 2018. The house is paid off. The accounts are healthy. I am not a woman who needs rescuing. My daughter Diane is 41. She married Ryan Calloway 7 years ago at a vineyard in Door County. I wore a pale gold dress and danced until 11 o'clock. I liked Ryan then. He had an easy laugh, and he looked at my daughter the way Gerald used to look at me. That was before I understood that some people's faces are their best performance. My son David lives in Portland with his husband Marcus and their 2 kids. He calls every Sunday. He has never once asked me if I'm managing okay. The trouble started, as it often does, with something small. Last January, I forgot a lunch. Diane and I had plans at a cafe downtown, and I simply forgot. I was in the middle of reorganizing my case archive, which I'd kept meticulously for 3 decades, and which I'd decided to donate to the law school, and I lost track of the afternoon. I called her the moment I remembered. She was understanding on the phone. Too understanding on the phone. Too understanding, the kind of understanding that stores itself up. 3 weeks later, she mentioned it at dinner, not accusatorially, conversationally, to Ryan, while I was sitting right there. Mom missed our lunch, just forgot completely. Ryan made a sympathetic sound. I said I'd already apologized and that everyone forgets things sometimes. Ryan said, "Of course, Eleanor, of course." That was the first time I noticed it, the way they communicated about me while I was in the room, as though I were already somewhere else. By March, Diane was calling 3 times a week. Was I sleeping well? Was I keeping up with my medications? I take a blood pressure pill and a low-dose aspirin. Nothing dramatic. Had I had the furnace checked? The questions weren't warm. They had the texture of documentation. I know that texture because I spent 31 years creating it. In April, she mentioned a doctor. My friend Cheryl uses this geriatric specialist, Dr. Ambrose Keller. He's wonderful, Mom. Very thorough. I just think a baseline cognitive assessment would give us all peace of mind. I told her I had a physician I'd seen for 16 years and that I had no interest in a stranger poking at my memory. She dropped it for 2 weeks. The thing about a sustained campaign is that it doesn't announce itself as one. It arrives in increments, each one reasonable enough on its own. The forgotten lunch, the gentle questions, the suggested doctor. Then Ryan mentioning that the house might be a lot to maintain alone. Then a Sunday call from David that felt slightly scripted, slightly coached. He asked 3 questions in a row that Diane had definitely fed him. I love my son. I know his voice. I know when someone has given him his lines. By June, I had started keeping notes. Old habit. 31 years of it. I kept a small notebook in the drawer of my bedside table, the kind with a dark green cover that you can get at any drugstore. Every conversation I wrote down. Date, time, what was said, by whom, in what tone, what was implied, what was omitted. I built careers on the difference between what people say and what they leave out. The first thing I wrote down back in January was Diane's response to apology was disproportionately gracious. Note, by June I had 43 pages. The visit that changed everything happened on a Thursday in late June. I hadn't invited anyone over. I came downstairs at 9:30 in the morning to find Ryan sitting at my kitchen table with a man I didn't know. Diane was at the counter making coffee like it was her kitchen. The man introduced himself as Dr. Keller. He had a soft handshake and the precise, unreadable expression of someone who has learned to seem neutral. I have that expression too. I recognized it. I sat down. I did not ask why they were there because I already understood why they were there. I spent 40 minutes answering Dr. Keller's questions. Some of them were genuine cognitive screening, repeating word sequences, drawing a clock, recalling a short story read aloud. I did all of it correctly and without effort. Some of his questions were subtler. Was I eating regularly? Did I feel isolated? Had there been any incidents of confusion recently? I answered honestly. I was eating well, thank you. I was not isolated. I had a book club, a weekly lunch with my former clerk, and I was consulting pro bono on 2 law school clinics. No recent confusion that I was aware of. After Dr. Keller left, Diane hugged me at the door and said, I just love you so much, Mom. I just want to make sure you're protected. I said, I know you do, sweetheart. I went upstairs and I wrote down every word Dr. Keller had asked me. I noted which questions were standard screening and which were leading. I noted the fact that Dr. Keller had not given me his card, had not mentioned his practice address, and had not asked for my own physician's contact information, which any ethical geriatric specialist would do before conducting an independent assessment. I wrote, possible retained by family, not independent. Follow-up. I called the state medical licensing board the next morning. Dr. Ambrose Keller had a valid license, no disciplinary actions, and a practice in Middleton. He was, I learned from his website, frequently retained by families navigating difficult elder care decisions. Difficult elder care decisions. Lovely phrase. I then called a woman named Gloria Park, who had been my clerk for 9 years before going into private practice. Gloria is 44, relentless, and specializes in elder law. I had recommended her to 6 families over the years. I told her what was happening. She was quiet for a moment, and then she said, Judge Hartley, when can you come in? I said, Is tomorrow too soon? She said, No, it's not. I want to explain something about Ryan Calloway because understanding him matters. Ryan is not stupid. He is, in the way of many intelligent people who lack good judgment, exactly smart enough to be dangerous. He'd run a small financial advisory practice for years. Nothing flashy, mostly local business owners and a few retirees. He was organized, persuasive, meticulous about appearances. He drove a car that was a little nicer than his income suggested. He took my daughter to Italy for their 5th anniversary, which he mentioned in conversation more than once. What I had not known, what I began to discover in the weeks after Dr. Keller's visit, was that Ryan's practice had been losing clients, quietly, gradually. 2 of the families I knew socially had moved their accounts elsewhere in the past year. One of them, a woman named Barbara Selznick, who'd attended my retirement party, mentioned it offhandedly at the Dane County Bar Association summer luncheon. Oh, we moved on from Ryan last spring, she said, the way you'd mentioned switching dry cleaners. When I asked why, she paused just a beat too long. We just wanted a change, she said. I noted it. I also spoke with David. Directly, not through the scripted calls. I called him on a Wednesday, not a Sunday, and I said, I need you to listen carefully, and I need you to tell me the truth about what Diane has told you. He was quiet for a long moment. Then he said, she told me you'd been having memory episodes, that you'd left the stove on twice, and that you'd gotten disoriented driving home from the grocery store. None of that had happened. Not once. I said, David, has any of that happened that you've personally witnessed or that I've told you about? Another silence. No, he said finally. I took her word for it. I told him I wasn't angry. I asked him to continue taking her calls as usual and to let me know if anything changed. He asked me what was going on. I said, I'll explain everything when I know everything. Give Marcus my love. The petition arrived on a Tuesday morning in late August. A formal petition for guardianship and conservatorship, filed in Dane County Circuit Court, case number neatly printed in the upper right corner. My daughter was requesting to be appointed my legal guardian on the grounds that I was exhibiting signs of cognitive decline that impaired my ability to manage my personal affairs and financial decisions. Dr. Keller's assessment was attached. It described me as demonstrating mild to moderate cognitive impairment with functional limitations consistent with early-stage dementia. I read it twice. The clinical language was careful, competent, and almost entirely fabricated. I set it on my kitchen table and made myself a cup of tea. Outside, the lake was doing what it does in late August, flat and silver in the morning light, a couple of early kayakers cutting slow lines through the water. I had watched that lake from this window for 37 years. Gerald used to say the lake was the best thing we'd ever bought. I thought they forgot that I'd seen this before, that I have sat on the other side of this table hundreds of times, that I know exactly what comes next. I called Gloria. Here is what Ryan had not accounted for. The house is in a trust. A revocable living trust I established in 2019 after Gerald passed, with the advice of a very good estate attorney named Howard Chun. The trustee, should I become incapacitated, is not Diane, it is David. Ryan had presumably looked at the surface of my estate and assumed the standard picture: widowed woman, large asset, adult children. He had not dug further, or if he had, he'd missed something. He had also not accounted for the fact that I had spent 3 decades watching families fight over exactly this kind of documentation, and that I knew which details mattered and which ones were noise. Gloria filed our response within 10 days. We requested an independent medical evaluation, not Dr. Term. Keller, whose financial relationship with families seeking guardianship we intended to raise. We filed a motion to compel disclosure of any financial arrangement between Dr. Keller and the petitioners. We submitted affidavits from 7 people, my physician of 16 years, 2 law school colleagues, the director of the clinic where I consulted, 3 members of my book club, all of them attesting to my cognitive clarity, my engagement, my complete functional competence. We also quietly requested Ryan's business financial records as part of establishing potential financial motive. What came back in discovery was clarifying. Ryan's practice had lost 40% of its managed assets over 18 months. He had 3 outstanding loans, 2 of them against personal property, and there was a newer account opened 8 months ago, the month after Diane first suggested Dr. Keller to me, in Diane's name, into which Ryan had been depositing client advisory fees that should have been reported to the firm, small amounts, regular intervals, the kind of thing that takes a while to notice if no one is looking. Someone had been looking, as it turned out. The Wisconsin Department of Financial Institutions had opened a preliminary inquiry 2 months prior. Ryan didn't know we knew that. Gloria asked me gently if I wanted to tell Diane what we'd found before the hearing. I thought about it for a long time. I thought about Door County in 2017, the pale gold dress, the way Ryan had looked at her. I said no. I needed Diane in that courtroom, believing she was going to win. The hearing was scheduled for a Thursday in October. I wore a charcoal blazer and the pearl earrings Gerald gave me for our 25th anniversary. I arrived exactly on time. Gloria was beside me. My former clerk, now a private attorney, sat 2 rows behind us as support. Diane and Ryan were already seated at the petitioner's table. Diane was in a navy dress. Ryan was in the suit he wore to important things. When I walked in, Ryan looked at me with an expression I had seen before, the specific look of someone who has done the math and is confident in the answer. Relaxed, almost sympathetic. Diane looked at the table. I sat down. I folded my hands. I waited. When Judge Patricia Okafor came through the door and took her seat, she did the thing judges do. A quick, professional scan of the room, both sides taking inventory. Her eyes moved to the respondent's table. She went still. I gave her a small nod. She cleared her throat, took 3 sips of her coffee. Then she said in a voice that was very carefully controlled, "Before we begin, I need to disclose for the record that I am personally acquainted with the respondent, Eleanor Hartley, in a professional capacity. If either party wishes to request recusal, now is the time." She paused. "If not, we will proceed, and I want both parties to understand that I will apply the same standard I apply in every proceeding in this court, which is to say, an exacting one." Ryan's attorney, a man I didn't recognize, leaned over and whispered something. Ryan shook his head slightly. They did not request recusal. Of course they didn't. They had Dr. Keller's assessment and what they thought was a clean petition. They believed they were winning. You don't pull the plug on a winning hand. Patricia Okafor had clerked for me for 2 years in the mid-90s. She was 26 when she came into my courtroom. I had written her recommendation letter for the judgeship. I had attended her investiture ceremony. She had sat in the chair I was sitting in now, learning how these hearings worked, watching me run them. She knew exactly what I was doing and why I was there. Ryan's attorney presented first. Dr. Keller's assessment, the petition's supporting documentation, 2 statements from neighbors who had apparently noticed my lights on at unusual hours, which I noted was not a cognitive symptom. It took 22 minutes. Then Gloria stood up. She was methodical and she was thorough and she was very, very good. She introduced the independent neuropsychological evaluation conducted by Dr. Rosario Mendez of UW Medical, who had assessed me 2 weeks prior over a 4-hour examination and found no evidence of cognitive impairment whatsoever. She introduced the 7 affidavits. She introduced my professional activities log, every consultation, every book club meeting, every legal clinic session from the past 12 months. She introduced the financial records. Ryan's attorney objected to the financial records strenuously. Judge Okafor overruled him without looking up from the documents. The financial records showed 2 things. First, that my estate was structured in a trust over which a guardianship would have limited practical effect, meaning the petition, if granted, would not actually give the petitioners access to my primary assets. Second, that Ryan Calloway had a compelling financial motivation to attempt to gain influence over whatever assets were accessible, the personal accounts, the discretionary funds, the day-to-day financial decisions that a guardian would control. When Gloria finished, the room was quiet in the way courtrooms get quiet when everyone has understood something at the same moment. I looked at my daughter. She was staring at the table in front of her. Her hands were flat against the wood. Ryan had gone a color that I recognized, the particular pallor of someone doing arithmetic in real time and arriving at a very bad number. Judge Okafor set down her coffee cup. The court finds no evidentiary basis for the appointment of a guardian or conservator for the respondent, Eleanor Hartley. The petition is dismissed. She paused. I am further referring the matter of Dr. Keller's assessment methodology to the State Medical Examining Board and the financial documentation presented today to the appropriate regulatory authority for review. Another pause, the kind that has weight to it. We're adjourned. She stood, and before she turned to leave, she looked at me just for a second, quick and direct. And the look said, I was paying attention back then. You taught me well. I thought, yes. That's the thing they never understood. You spend 30 years in a courtroom and you don't just accumulate experience. You accumulate people who watched how you did things, people who carry it forward. Ryan was already talking quietly and urgently to his attorney. Diane hadn't moved. I waited until Ryan left the table before I walked over to her. She looked up at me. Her eyes were red. She looked like she did at 12 years old when she broke in the kitchen window and hadn't told me for 3 days, that exact specific expression of someone who has been holding something terrible and is exhausted from the holding. I sat down beside her. "Mom," she started. Her voice cracked on the single syllable. "I know," I said. I didn't know what he was. She stopped, started again. "He told me you were getting worse, that you needed help, that if we didn't act now, the state would get involved and it would be so much harder." I believed him. I believed everything he said because I was scared, and she pressed her hand over her mouth. I thought about that for a moment. I thought about the fact that my daughter had been frightened, and that frightened people make decisions they might not otherwise make, and that someone had been very deliberately frightening her. "I know you were scared," I said. "I know he's good at this." She started to cry then. Quietly, with her hand still half covering her mouth, the way she used to cry as a girl when she was trying not to. I put my arm around her. I didn't say anything else for a while. That was 7 months ago. Ryan and Diane separated in November. The regulatory inquiry turned into a formal investigation. I don't know where it stands now because it isn't my case to follow, but Gloria has told me it's ongoing. Dr. Keller's arrangement with families seeking guardianship is apparently of significant interest to the medical board. David came to visit in December with Marcus and the kids. We had Christmas dinner at the house. The same table, the same lake view, the same dishes my mother left me that I've been using for 40 years. Diane came on the second day. She and David talked for a long time in the sunroom while the kids played in the snow. I didn't ask what they said. Some conversations belong to the people having them. She comes for dinner every other Sunday now. Sometimes she brings a bottle of wine. Sometimes we just make tea and sit at the kitchen table and talk the way we used to talk, before all of it. She is working with a therapist, a good one, she says, who is helping her understand how she got so thoroughly turned around. The green notebook is still in my bedside drawer. I haven't opened it since October. People ask me sometimes, my book club friends, my former colleagues, whether I was angry, whether I am angry. It's a reasonable question. I was methodical, not serene. There were nights in that long stretch between January and October when I sat at this kitchen table at 2 a.m. and felt something that had teeth to it, something that had nothing to do with calm. But I've spent a lifetime watching what anger does to people in courtrooms. It makes them reach too far. It makes them say things they can't unsay. It makes them stop paying attention to what's actually in front of them because they're too busy looking at what they've already decided is there. I paid attention instead. I wrote things down. I called Gloria. I waited for the right moment. 31 years on the bench teaches you something about patience. It teaches you that the truth has a way of surfacing if you give it the right conditions and stay out of its way. You don't have to chase it. You don't have to force it. You just have to make sure you're there when it arrives. I was there. The lake outside my window looks the same as it always has. Silver in the morning. Sometimes gold in the late afternoon when the light comes across at that particular angle and everything gets warm for a few minutes before the sun drops. Gerald used to say it was the best thing we'd ever bought. I think he was right. I think we did all right, the two of us. I think I'm doing all right still. I'm going to make some tea now and sit by the water for a while. They forgot I'd seen all of it before. That was their mistake. I've thought a lot about what Ryan actually believed when he filed that petition. I think he genuinely thought he'd found a clean situation. Older woman, large house, no husband, a daughter who was scared and willing. He'd done this kind of math before. I could tell by how organized it was, how patient. He wasn't improvising. He was running a process he trusted. What he didn't understand is that every process has assumptions built into it. And when the assumptions are wrong, the whole thing comes apart from the inside. His assumption was that I was what I appeared to be, a retired woman, alone, soft around the edges in the way he expected women my age to be soft. He looked at 68 years and a quiet life on a lake, and he saw an easy situation. He never once considered that the quiet might be intentional, that stillness and weakness are not the same thing. I don't say this to be proud. I say it because I think it's the most important thing I've learned in my life, and I learned it slowly, over decades, by watching what happens to people who stop paying attention. The ones who get hurt the worst in courtrooms and in life are almost never the ones who are outmatched. They're the ones who stopped watching, who assumed the situation was settled when it wasn't, who let comfort make them careless. Ryan got careless. He stopped watching me the moment he decided what I was. I kept watching him the entire time. Diane is a harder thing to reckon with. My own daughter, I've sat with that a long time. I've asked myself the question that I think anyone would ask. How do you forgive someone for that? And what I keep coming back to is this. Diane didn't do what she did out of cruelty. She did it out of fear, and fear is something I understand. Fear makes you reach for the nearest explanation, the nearest person, the nearest plan. Ryan was right there. He was confident and organized, and he told her a story that let her believe she was being a good daughter instead of a frightened one. She needed that story. He knew she needed it. That's not an excuse, but it's an explanation, and I've found over a long life that understanding why someone did a thing is usually more useful than deciding how much to resent them for it. What I know for certain is this: the choices we make when we're frightened are still our choices. Diane will have to live with that, and I think she knows it. What I also know is that she's doing the work now, real work, not the performative kind. That counts for something. That counts for a lot. As for me, I kept a green notebook. I called the right person. I waited. None of that felt heroic while I was doing it. It felt like the only reasonable response to an unreasonable situation. You document. You verify. You don't move until you understand what you're actually dealing with. That's not a strategy I invented. That's just what careful attention looks like when you've practiced it long enough. The lake is still there outside my window. Diane comes for dinner. David called last Sunday and talked for an hour. The notebook is in the drawer and I haven't opened it. Some things resolve. That's the part they don't tell you. Not everything does, but some things do. And when they do, it's almost never because someone got lucky. It's because somewhere along the way, somebody refused to stop paying attention. I refused. That's all it was in the end. That's everything it was.